Okay. So just disclaimer to start off with, lawyers love disclaimers. This presentation is general discussion of estate planning issues. It's not legal advice. If you need legal advice, you need to consult with a competent estate planning attorney about your particular situation. Maybe that's me, hopefully. And so yeah, now we'll start going. And just to begin with, at the end, we will be open for questions. I'm heavily caffeinated, so this will probably take, go quicker than I anticipate. So we'll have plenty of time. You can write on the side, I believe, on the Zoom if you have questions, and then we'll just get to the end. And to begin with, just an overview of what we're going to be talking about today. We're going to talk about estate planning practice, the value, what it is. We're going to talk a little bit about probate administration, methods to avoid it. And then I'm also going to talk about handling real property after death. For all you brokers out there, you definitely face these situations and sort of some things that I think about when this ends up happening. Okay, next slide. Okay, estate planning. So what is it now, and why do people do it? Now, estate planning is really a method. A client comes to me and what are they concerned about? Okay, well, things I bring up to them is it's not only after death that we need to be concerned about, but during life, what happens if for some reason you get an accident, you can't make financial decisions, or for an older couple, they end up losing capacity because of dementia for whatever reason, and they can't sign legal documents. How do we plan for that? Well, we may need to do a advanced healthcare directive or for their healthcare needs, or a power of attorney for their financial needs, or basically a trust document, which will provide what happens if they can't make financial decisions for their trust documents. So that's one thing we do in estate planning. Another thing we do is we decide, hey, how do you want your assets, and who do you want them to go to when you die, and when do they get it? For example, you may want to, give some specific requests, 10,000s to all my nieces and nephews, or I want to make sure that they don't get it if they're under 25, at 18, they get it at age 25. So, you can provide for that. You can also, it can help simplify how property goes at the death. For example, I have 3 kids. I want them all to receive it equally. I have a home, a vacation home, it's financial assets. You don't know what those financial assets are going to be 20 years from now when you die. But maybe what you're going to do is you're going to say, hey, after they die, the trustee makes sure everything's split equally. My daughter Mary wants to live at the house. She gets the house. My son Junior wants the vacation home. He gets the vacation home. And, the rest of the assets can, go to the other daughter, and you can make it up. So in a trust, you can do that. And you can provide for that because it's really a customized document. All right, next slide. So what is estate planning in 2021? Now, traditionally, a lot of people had to worry about the estate tax. It's not really, or also known as the death tax. Right now, it's not really a big issue with most clients, and primarily because it really only affects you if you died this year and you had, as a single individual, had less than $11.2 million, you're not going to pay estate tax. Now, that with the caveat, if you made transfers during life, gift tax, if filed gift tax return, that also lowers that amount. But it's $11 million per individual, $22 million per couple. It really does affect people. Now, saying that, laws always change. And in 2026, that number is cut in half, and the exemption amount, and with the current administration, with taxes and everything, those it could maybe lower. So although for the vast majority of clients, we're not worried about the estate tax, things could change, and we always need to be aware about it. And so what we're primarily worried about is not only what was on that first slide, but ways to avoid probate administration. Next slide. Okay, what is probate administration? Probate administration is basically a court supervised process that determines how your assets at your death are distributed. It covers, if you're a single individual, covers all of the assets subject to your estate. And if you're a married individual, it covers your separate property and your half interest in any community property you have. Now, some of the disadvantages of probate and why a lot of people try to avoid it is there's a delay in the process. Between me and my colleague, who's been practicing for 25 years, my colleague has, quickest this ever has happened is 8 months, which is a very simple one. You go anywhere for a year and a half. In these day and times, with the court being backed up, it's taking a lot longer to get hearings, so it's probably going to be even worse right now. It's public, a probate administration. Your nosy neighbor could know, how much assets you have in your estate. When you died, who those assets went to. A lot of people try to avoid that. It's also expensive. And as I'll say in the next slide. Okay, so probate expense. So based only on state law, there's huge expenses. Oh, and just a side note, just says before, I practice in California. This is California centric. I don't, for those that are outside the state, this isn't as relevant for you, but it's definitely relevant for those in California. So based on state law, there's statutory ordinary fees that an attorney receives and a personal representative for representing the estate in a probate proceeding. They get 4% of the first 100,000 of gross assets, 3% of the next 100,000, 2% of every additional 100,000, up to about $1 million. So what that means is, let's say there's a $200,000 home, and that's all there is, just for simplicity's sake, in the estate. You would get 4% to the first 100,000, so that's $4,000, 3% of the next 100,000. So that would be just $7,000 straight out to the attorney and the probate and the personal representative. So it's $14,000 on basically a $200,000 home. And the other thing people don't know about that is that's gross. So let's say there was a mortgage on that home for $100,000 or whatever. And there's only an equity of $100,000. That doesn't matter. Even on basically $100,000 of equity, the attorney would still get $7,000, and the personal representative would get another $7,000 as well. And that also doesn't count the costs of filing a petition, the publication in the newspaper that is required. Modesto B requires $600 for that publication, and other counties are different depending on the county and publication. And also, the probate referee fees. So, for basically, we did a probate recently, $200,000 simple home, incurred $14,000 of legal and administrative costs, and it's about $2,000 of extra costs between filing fees, the publication, and all that. So it's expensive. And all of these expenses doesn't even count extraordinary services, which are on top of that at the billable rate of the attorney and the personal representative. For example, selling real estate and probate administration, or if there's any litigation, will contesting. So, it adds up. It's expensive, and that's primarily why people try to avoid it. So it's always, the whole thing, penny wise, pound foolish. Some people try to save money by not doing estate planning, but it ends up costing their estate more money in the long run. Next slide. Now, saying that, there's benefits of probate administration. Some clients will come in and based on the circumstances, we may recommend to them to do a probate administration. And things to think about is, if you're just doing a trust, you really need to trust that trustee. And sometimes clients just don't have those. Like, let's say it's an older individual, they're new to Modesto, their son lives over across the country. They want to leave some assets to their son, some assets to charities, whatnot. Maybe they just don't have somebody they want to name as trustee. And then, maybe good to look over that person's shoulder. And you can use professional fiduciaries, corporate trustees, which can, but maybe it's just good to have the court look over and check those boxes and make sure everything's happening. We're talking about hundreds of thousands of dollars many times, and temptation is real. Now, also, there's enhanced creditor protections in a probate administration. So for an estate that has a lot of creditors, credit card debt, it's sometimes good to use a probate administration. I'm aware of a case where the beneficiaries thought it was an insolvent estate because of huge credit card debt. They entered a probate administration. They submitted their, creditor notices. They had 120 days for the credit card companies to respond. They decided not to submit the claims for those credit card debts, and for tens of thousands of dollars. And because they didn't submit a claim within the 120-day period, they were barred from collecting on that debt. And as a result, the beneficiaries actually got some money. The other good reason for probate administration is if you think there's potential litigation. If you think that you're admitting an heir and that heir maybe is going to sue your other, beloved child, or for whatever reason, it's good to have the court be involved to check all the boxes, look over their shoulders, give their seal of approval to prevent in the future that unsatisfied heir is not going to sue your beloved child. Okay. And the other thing is, like anything, benefits come with costs. So obviously it's expensive for probate administration, but in some states it's, obviously valuable to pay that cost. Next slide. All right, so methods to avoid probate. One of the most common ways, and what we do with a lot of clients, is create a revocable trust. Because assets you put in the revocable trust are not included in the estate, and therefore not subject to probate administration. Now, what I like to look at as a trust as really like a gift box. Husband and wife, they put assets into this gift box, and when it's in that gift box, they can pull it out, put it in during their lifetimes. It's still for tax purposes under their taxable ID as long as it's a revocable trust. And then at their death, depending on terms of trust, primarily, the gift box opens up on the bottom and goes to the heirs. Now, so the assets that are in that gift box are governed by the trust document. When the other individual takes over, when the trustees take over, terms of their incapacitation, how the assets are distributed, out of the gift box, at the person's death, all those things is governed by the document. Now, the trustees also are the ones that have control and the powers listed in the trust document. For example, they, power to sell, go back, Jordan, the power to sell, the power to mortgage, all those assets the trustees have control over. And typically, if it's husband and wife, they're the initial trustees. And then whether incapacitation or death, the other one becomes a sole trustee, and you name the other successor trustees after that. But the big key here is you got to fund the trust. If you don't fund the trust, and what that means is transferring the assets into the gift box, then it's like it didn't matter. It's like you built this amazing race car and you just failed to put gas in it. It doesn't go anywhere. Now, there is some fail-safe ways you can do with the court to get assets subject to the administration of the trust. But if you're going to put all the money into making the race car, put some gas in it to make it go where you need to go. And for example, funding it would be if you want your home to be part of the trust, then let's do a grant deed, get it executed when you come into the estate planning practitioner, and deed it over to Jane Smith and Mary Smith as trustees of the Smith Family Trust, right? And if it's a bank account, bring your something called certification of trust to the bank. Tell them, hey, this is how I want my title of this bank account held, and do that because it saves money and costs later down the road. Okay, to our next slide. All right, other methods to avoid probate. So if something is governed by contract, it's also not a property of your estate. Now, what does that mean? So for your life insurance accounts, your annuities, your something called pay on death accounts for financial accounts, those go to the listed designated beneficiaries. You got to be careful when those are minors because that would cause problems in the future. But generally, the idea of, if you have life insurance, annuity, all those things, it's not going to be subject to estate. Oh, another disclaimer. I mean, all this stuff is just general knowledge. I mean, my viewpoint is you're going to talk to a lawyer about this. I'm just trying to provide, based on my perspective, what these things happen. Now, the other thing to think about is there's something called a small estate affidavit that would avoid probate. And that in California right now is assets of less than $166,250, but that's non-real estate assets. If it was real estate assets, it has to be less than 50 grand. I mean, what in California is going to be less than 50 grand, maybe a plot of land. And the other idea is if the property is held according to the title, if it's joint tenancy or community property with right of survivorship, it goes automatically to the other heir after you file an affidavit of joint tenancy, in death of joint tenancy, or so those would not be subject to probate administration. One important note, some people don't realize this, even if you did a will and you didn't do a trust, your property could be subject, your assets could be subject to probate administration. Because really you got to look at the will as basically as a letter to a judge saying, hey, I died, this is what I want to happen to my assets. And if you're talking to a judge, you're subject to court, you're subject to all those legal fees. Now, I mean, that's sometimes very necessary. For example, on wills, we write who your guardian of your children will be on the death of, both spouses. And that's basically the letter to the judge, and you need to do that. But it's not going to help you avoid probate. Next slide. Okay, handling property of the deceased. All right, so now the owner of the property has died, and you have to figure out, what do I do with this? How do I get it to the intended beneficiaries? Well, first things you do, first thing you do is you check the title of the property. How is this property held? Does it say, like my example, James Smith is trustee of the Smith Family Trust? Great. Okay. Well, then we look at the trust document. Well, the trustee does, successor trustee, and the trust document's going to govern that is. Now, let's say it just says James Smith as sole and separate property. Okay. Well, then the question is, did James Smith actually have a trust out there? If he had a trust out there, but he just never funded it, or for example, James Smith was refinancing his home, it was in the trust, but then he pulled it out of the trust to get it refinanced, which is sometimes required, but never failed to put it back in. That happens, but his intention was to have it in there. Then we want to, we do something called a Hagstad petition, 850 petition. There's a lot of different names for it. And we file a petition with the court and say, even though this wasn't on title with the name of the trust, it really should be. And depending on the circumstances of the case, the court allows that. It's only one petition. You're not paying all those legal fees for a formal probate. Is the property worth less than $166,000 with all the other assets of the estate? If it is, there's one petition that you can file with the court. It's one petition, one hearing. Once again, much quicker. And you can file it with the court, and then as long as the court gives seal approval, you're okay. Now you may be thinking, what property is less than $166,000? Well, you can sort of, there's some stuff we do with this in Merced and south of us in that county, where you don't think it's worth less than that, but maybe there's some deferred maintenance. Maybe the roof needs repairs. Maybe grandmother was very sick and didn't really do a lot of work. The kitchen needs a lot of upgrades. You can't sell it. There's issues. So sometimes you bring that. It's going to have to take the seal approval of something called a probate referee, who's going to assess that. But you bring those issues to their case and say, although it says this, there's these other issues when you actually peel the onion off and look at it that have issues, so it'd be less. And if they give their seal of approval to a less value, then you could just file a petition, not be subject to formal probate. The other thing is if, let's say it's husband and wife, and husband dies, and this is community property, there's a spousal petition that could be filed that could bring it into surviving spouse. But once again, it's a petition you file, not as expensive as a formal probate, but still, once again, you got the costs. So all these things is sort of, hey, they didn't do a trust, and we're just trying to figure out different ways to solve this problem. And all of them are more expensive than just carrying out and creating the trust to begin with, and using somebody who is going to fund it and take care of what you need to do. So that's the moral of the story: is create the trust so you don't have these extra costs and problem solvings down the road. Next slide, Jordan. Okay, so important things to consider. Typically, the idea of joint tenancy. Now, the thing you got to consider about joint tenancy is, so let's say, for example, Jordan and I were friends. We're like, hey, we want to go buy this property, this rental, and we want to buy it as partners, right? So we go out and we buy this property. We both put 50-50 up, and we buy it, and now we put Andrew Dignan and Jordan Verma as joint tenancies. Well, at that situation, I pass away first. It's going to go out right to Jordan. All right, well, maybe that's not really what we wanted. Maybe what we were really thinking of was I wanted my 50% to go to my kids at my death. Jordan wanted 50% of his to go his kids at death. So joint tenancy, although it helps avoid probate, it's not always what the clients want. So once again, talk to an estate planning attorney about this. Now, the other thing to think about is there's something called step up in basis. Now, at the death of the individual, you get a step up in basis for your assets. So I own a house outright, I die, and I bought it for $100,000. Now it's worth $400,000, and it's going to be sold after my death. And therefore, it's not going to be for the heirs are going to be sold. The heirs are going to sell it after my death. It's not going to be have a tax basis of $100,000. A tax basis of $400,000. So it helps for capital gains. Now with joint tenancy, you only get a step up in basis on half of that asset. So, Jordan and I buy a house at $100,000. I die. It's now worth $400,000. Jordan now has 100% of the value, and he goes out to sell it. He's going to get a step up in basis that my 50% interest, instead of being at 50 grand, it's at 200,000. And, so that's interesting. Now, the other thing to think about is there's actually advantages for community property. So if it's husband and wife and they own a property together, me and my wife marry, and we have it as community property with right of survivorship, I die, the community property goes up, it's for 100% of the value. So we bought it for 100,000, it's now at 400,000. For our rental, she decides to sell it after my death. Instead of it being the basis being 100,000, it's now 400,000 for the full value, and she can sell that tax-free. Now, you need to be wary, obviously, of community property, separate property. Talk to a estate planning attorney, talk to a family law attorney. There's transmutation rules, depending on if it was separate property before or community property. There's divorce and death consequences. You gotta be really wary of doing that. The client needs to, because there can be consequences of this. But assuming that it's husband and wife, and assuming that it's truly community property, it's husband and wife should hold property as community property with right of survivorship over joint tenancy. One of the first things we do when we transfer stuff to trust, just to ensure we get the 100% step-up basis on the whole property, is we transfer assets that say, Mary Smith and John Smith as joint tenants, we transfer that to Mary Smith and John Smith as community property rights survivorship, and then we transfer to the trust to ensure that the court allows us to get 100% step up in basis. Minors should not be untitled. Critical. If grandma comes in, it's like, you know what, I love my grandchildren, I want to put everybody on the deed. Okay. The problem is, if we now want to take those minors off the deed, we're going to have to go to court, get guardian ad litems for those children, court proceeding, and it's going to be a mess. So just don't put minors on title. If a client wants to put minors on title, have them talk to a lawyer about it, talk about the consequences and what's involved. Minors should not be on title. An interesting note, if you are in probate, there's a special sales form because a personal representative has no represents and warranties for the property. It's as is. So that's something important to look at. Just flag it. Make sure you talk to somebody that knows what form to use, because you're not going to use just a typical sales form. Well, next slide. So yeah, that went very quickly. A lot of information there. I'm definitely happy to take any questions. Once again, my contact information is right there. My practice in Modesto, our phone number, happy for estate planning, wills, trust, probate administration, trust administration. Also help out with beneficiaries that are in legal litigation to try to protect their rights.